días.
Good morning. Good morning, colleagues. This is a public session. I would also therefore like to wish a very good morning to those who join us for this meeting. Good morning also to conference services, interpreters and précis writers and the secretariat. I hope you enjoyed your weekend, particularly committee member colleagues who worked so hard last week. Let us begin our work. This is meeting 3243 of the Human Rights Committee. This is a public session to begin with. We have 2 hours in public session to pursue our consideration of the draft comment, general comment on Article 6 of the Covenant, Right to Life. I would like to announce at this point that a minor modification has been made to the programme of work. And next time we consider the general comment will not be the 18th in the afternoon as anticipated, rather Monday the 21st of March in the afternoon. This is at the request... My apologies, says the chair. That change has been made. I do have the new programme of work in front of me, so as on the programme in front of you, the modified version. Right, since things were clear, I was just trying to confuse you a little. All right, let's begin our work. At this point, I would like to give the floor to one of the co-rapporteurs on the draft general comment. As you know, the rapporteurs are Sainat El-Rodli and Mr. Yuval Shani, and I would like to give the floor, first of all, to Mr. Yuval Shani. Mr. Shani, you have the floor.
Yes. Thank you very much, sir. Just to recap, we have been, in the previous session, we have been able to go through paragraphs 1 to 5. I should say that 1 to 5 is already, it means 1 to 4 in the original version because we added 1 paragraph. So now we have 1 to 5 which had been adopted and a revised text in translation had been circulated. Now what we will do today and also in the next session on Friday would be to collect as many comments as we can from members of the committee on the specific formulations that are proposed for paragraphs for the remainder of the paragraphs in part 1 to the extent that we will be able to cover as many paragraphs as we can in that regard. There are all in all 16 paragraphs in part 1. So we will try to collect the comments and we would circulate before the meeting on Tuesday. We would try to circulate proposed changes which would reflect the comments made by members, and then we will, on that last session dedicated to the general comments for this session, we would try to approve as many specific formulated paragraphs as we can. So this is the game plan, and we would then invite members to present their comments. You want to add something, Nigel, before I introduce paragraph 6?
Just very briefly, of course, to second that and to say that we didn't make as much progress as would have been desirable last time. So the slightly new methodology this time that we will feed back at the end of the discussions of the various paragraphs is designed to try and facilitate that, but also a little bit of the risk of sounding preachy, which I don't mean to do, a little bit of self-control of colleagues so that they obviously they don't want to sacrifice principles they're wedded to, and but at the same time not everything is an issue of principle, and we we do have to try and make progress and adjust to each other and try and find a reasonable basis of consensus without taking too much time on every paragraph and sometimes on every every sentence of every paragraph. So just that appeal to colleagues to a certain cooperative self-discipline. Thank you very much, sir.
Muy bien, muchas gracias.
Very well, thank you very much, Sir Nigel. I would echo your words. Thank you for voicing the desire to pursue this debate in the most efficient way possible. Let's begin, therefore, our consideration of paragraph 6. Mr. Shani, please.
Thank you. I'll be very brief. Paragraph 6 is designed to delineate the differences between Article 6 and some of the other related human rights, namely in the field of economic and social rights. So it is designed to distinguish between the right to life and the right to health, or the right to body integrity or standard of living, and also Article 9, the right to personal security. It does, however, conclude with an important observation, that is that the article would require to address even threats to life which do not result in the right in a violation of the right to life. So the obligation of states is conduct oriented and not result oriented in this regard. I welcome comments by colleagues.
Muy bien, muchas gracias.
Thank you very much. I'm going to open the floor. Mr. Politi, please.
Yeah, thank you, Chair, and thanks to the rapporteur for the introduction to paragraph 6, and I'll take Mr. Nigel's suggestion that I'm trying to be as cooperative as possible. Not everything is a matter of principles, but I may have some questions, a couple of questions. I hope he doesn't mind if I ask questions, maybe make some suggestions. At the beginning of paragraph 6, my first question relates to the use of the word infliction. And the question is it intended to exclude acts of omissions, failure to do something, failure to grant something to individuals that would result in loss of life. And I may have some suggestions in this respect, depending on the answer, with regard to the examples of deprivation of life that are indicated in the second sentence. This is my first comment, the first question and comment. The second relates to the reference to injury that goes beyond mere damage to health, body integrity, or standard of living. It's not clear to me what it means goes beyond. Aren't we talking about a situation where the injury produces, in fact, damage that result in the termination of life, something like that? So here I may have a drafting suggestion, and I may probably would prefer, depending on the answer that I receive from the rapporteurs, to say injury that produces loss of life as a result of damage to health, body integrity, or standard of living. Thank you, but I look forward to the answers. I may withdraw everything, but these are the questions that were raised in my mind by reading the first sentence, which is the key sentence of the entire paragraph. Thank you.
Muy bien, muchas gracias.
Thank you very much. Mr. Benachur, please.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I have some points I would like to make with regard to paragraph 6. There are, firstly, some editorial points in the French version. I will supply those in due course. I do, however, have some three remarks of a general nature to make. first relates to line 4. Examples of deprivations of life visées in the French, regulated by Article 6. Visé in the French version. What I'm bothered about in the French version is visé, targeted, as it were, because at least in the French version, that one has the impression that Article 6 evokes instances which are mentioned here. However, here we are in fact looking at interpretation. Article 6 does not focus on target, etc. Rather, it is interpreted as covering the carrying out of a death sentence, extrajudiciary killings, and so on. So I think the wording should therefore be modified to say, for example, examples of deprivations that could be considered as being covered by Article 6. Visé in French, the regulated in English, is out of place here. The second point I wanted to raise on this paragraph relates to the end of the paragraph when we indicate that deprivation of life also represents a more serious attack against the lives of individuals than general threats or attacks directed against their personal security. I entirely agree with the notion, but I do not fully understand what general means here. General threats or attacks. If the rapporteurs are agreeable, I feel we could perhaps avoid this expression and simply say threats or attacks directed against their personal security without the general. And my third and last point is as follows. The term still, Article 6 may require states, parties, and so on, is not appropriate here because these still seem to be opposing one point against another, and then I do not see any opposition. I think we could get rid of still, cependant in the French, and say simply Article 6 may require state parties too, and so on. These are the 3 points I wanted to make. Thank you for your attention, Chair.
Muchas gracias, señor Benachot.
Thank you very much, Mr. Benachot. Mr. de Frouville, please. Yes, you have the floor, sir, Mr. de Frouville. Thank you, Chairman. I'm sorry. I hadn't quite heard you there. Allow me first of all to thank the co-rapporteurs once again for their proposed language. Some of my points are in line with what has been said by Mr. Politi and Mr. Benachot. My comments particularly relate to a doubt which to an extent has been dispelled by Mr. Chani's introduction with regard to the general objective of this paragraph. If truth be told, I find it difficult to work out exactly what the objective is, or I do have a little more clarity now, thanks in part to Mr. Chani's introductory remarks, but I do have to say that at the same time, that has created some more questions in my mind. As I understand it, in light of reading this paragraph and in light of the explanations given, once again, this paragraph is intended to clarify the scope of application of the right to life, Article 6, which enshrines the right to life, seeking to make clear what forms of violation, action, and omission may relate to the right to life and where it may apply. And a distinction seems to be applied here fairly clearly between 2 major areas of act or omissions. On the one hand, those that lead to the deprivation of life. That is the first sentence, which seems to be illustrated by a list of acts. I will come back to that later. And then the second category, where we have situations where life is placed in jeopardy or in danger. So we have acts or omissions that lead to deprivation of life, and on the other hand, acts or omissions that lead to situations that place life in danger, with states being deemed to be responsible and therefore obligations to be undertaken by that state. With regard to the first form of act or omission leading to the deprivation of life, I have a first point to make as follows. The inclusion in the drafting which is placed before us of a notion of intention or fault in a human rights text, I feel that notion is inappropriate. This is not a text relating to international criminal law. We're talking about acts or omissions which may be deemed to be applicable to the state or at the fault of the state. Rather, it seems here that in fact that we are talking about the infliction, the deliberate infliction or otherwise foreseeable and preventable of life-terminating harm. So this notion of deliberate, ultimately intentional or foreseeable and preventable, which would suggest the notion of fault, leads us towards criminal law as opposed to human rights law, and I do not believe that the Human Rights Committee has ever before used this term. We do have a footnote in the English text that refers back to Human Rights Committee's findings. I don't have the English text in front of me, but I have checked the citation. But this is a very specific case where we can see that an arbitrary execution is the result of a deliberate action by a state, but we cannot extend specific findings from one case in a general way and derive a general principle out of it. That's the first point I wanted to make. Secondly, for situations that place life in danger, I jump to the end of the paragraph now. This last sentence of the paragraph begins with still, which would seem to downplay these types of situations. It suggests there is a degree of subsidiarity. We have the general instance of the deprivation of life and then the subsidiary state of affairs, still, despite the above, notwithstanding, on an exceptional basis, if you will, where Article 6 may also cover threats to life. This still, or cependant in the French, is problematic to me because I do not see why we have this linkage between the key idea and the subsidiary notion. I think Article 6, as we've seen in the committee's jurisprudence, covers all types of situation, both of the above, and I think we do need to do away with this still and avoid the somehow downplaying of this threat to life. Article 6 may require. Here, that is also problematic. Article 6 does require, quite simply. So we have, again, this subsidiarity emerging, this nuance in the language, which might be seen as placing this type of situation on a lower footing, and I do not see the reason for this. Coming back again to harm, life-threatening harm. I don't think there can be life-threatening harm. It's situations that place life in danger. There are situations where the state should have acted, could have acted, or did indeed act, and as a result of the above, life was placed in danger. This is not a harm. There are various types of situation of this kind. We have an exemplary list for the first category, but we do not have a list for the second category. I believe that there should be a list for the second category. If we've done it for the first category, we should do it for the second. Particularly since we have numerous examples within the draft general comment. We have enforced disappearance in paragraph 7, which comes afterwards. We have non-lethal weapons, which are mentioned in paragraph 15, which which also speaks to the need to prevent situations where states are failing to take measures to prevent threat to life. We have various other examples mentioned in paragraph 25 also. For example, curbing the proliferation of illegal weapons, limiting the use of anti-personnel mines. This is a matter of state responsibility. And then final point, Chair, Mr. Shani states that one of the substantive intentions of this paragraph, where I had doubts, was to establish limitations, in other words, draw boundaries with the economic, social and cultural rights. And I have to say that I fail to understand the thinking behind this. I will give two reasons for this. I'll try to keep it brief. I think from the very outset of this discussion, and as you recalled, when we marked the 50th anniversary of the two covenants, as you've recalled, drawing a line between these covenants is becoming ever more difficult. It's very hard to draw a clear dividing line between these two categories of rights. Secondly, it has to be said that there are various situations where actions and omissions of the state place life in danger, and they, for example, may jeopardize the health of persons through pollution which is allowed to proliferate, for example, or where a state fails to take steps to address an epidemic. This may undermine the right to health. So there are any number of situations which could be exemplified where the state needs to take certain measures to prevent a threat to life, but where economic, social and cultural rights are affected. I feel this attempt to delimit these rights is going to be tricky. When it comes to the right to safety and security, I have difficulty understanding that. That's the sentence in the middle. I think that requires fleshing out. I will not dwell on that, however, and I will stop at that point. Thank you, Chairman.
Gracias, señor.
Thank you, Mr. Fatala.
Thank you, Mr. Chairman. Mr. Chairman, we have two concepts in this paragraph 6. The first one is a clear one, which is related to the deprivation of life. And here I have no problem because we have very clear cases. If we state death penalty, murder, and so on, we have clear cases we can enumerate. But for the second part, when we speak about foreseeable and preventable infliction of life, terminating harm, and so on, I think in this case we should put it in a separate sentence. We should have two sentences, and here we should put inter alia, because we cannot just have a complete list of what is foreseeable or preventable. As Monsieur de Prouville just stated now, for instance, if we speak about pollution, about the environment, and there are too many cases concerning preventable or foreseeable, which can put obligation on the state party. Therefore, I think that we should make a difference in the same paragraph between these two issues. As for the last sentence of paragraph 6, I personally don't know, because I don't understand it, because it's still Article 6 may require state parties, and then may require what? How it's may require. I read carefully Article 6. To address threat to life and life-threatening harms and injuries that do not result in loss of life. How we can deal with issue which is not related or result to the loss of life. And we speak at the start of the beginning of the sentence of may, and then we say at the end also we confirm do not result in loss of life. I need some explanation concerning this last sentence. Thank you, Mr. Chair.
Muchas gracias.
Thank you very much for that. Ms. Seiberfor?
Thank you very much, Mr. Chairman. I think that part of the problems which have been raised so far in the discussion, in particular by Monsieur de Frouville, are part to the fact that this paragraph doesn't properly distinguish between negative and positive obligations of the states parties. And I think we should make an extra effort in laying that out. I think instead of couching everything together under the notion of deprivation of life, I think we should distinguish between, first of all, the taking of life by the states parties, the protection of the life, any kind of action of the state party which is attributable to the state party itself, I think there is a broad range of obligations that the state is undertaking, and then the positive obligations in terms of protection against the taking of life by other people. I think by couching everything under the deprivation of life, I think we are making a fatal mistake, because either we are overexpanding the obligations of states, or we are under-inclusive, and I think that doesn't make any sense. So with regard to the positive obligations, I think we should consider more that these are due diligence obligations, and we should distinguish between them. If I read paragraph 5 now, we are dealing with very different scenarios. For example, the death penalty, which would be exercised by the state party on the one hand side, and on the other hand, we are talking about road traffic death. This is not the same, because I suppose that the rapporteurs are speaking about road traffic death incurred by private people from private people, and therefore I think it would be more appropriate and worthwhile considering to what extent are states obliged with regard to negative and positive obligations. Thank you.
Muchas gracias.
Thank you. Over to Mr. Singh.
Thank you, Chairman. I just have a few brief points to make after having listened to my colleagues. First, I have a little problem with the word regulated, so in the third line. So I would suggest that we use the word covered, because we don't find any kind of regulatory approach in Article 6 itself. And then concerning the second sentence, I have a suggestion concerning this pertains to a more serious attack than general threats or attacks, which seems to be a bit confusing, at least to me. I would suggest that we say deprivation of life also represents a serious attack against the lives of individuals, rather than general threats or attacks, because more serious attack when compared to general threats or attacks, to me is, as I've said, slightly confusing. And finally, much has been said about the last sentence, and I would suggest in that case, and I agree with the comments which have been made, I wouldn't use the word still, and I would go straight to saying that Article 6 requires state parties to address threats to life and life-threatening harms and injuries that may result in loss of life. Because when we say that do not result in the loss of life, we are saying what has happened. We are considering the situation after the event. But in this case, we want to cover a situation where the threats to life and life-threatening harms and injuries may result in loss of life, and we are not looking at what has happened after the event, because after the event there would have been no loss in life. So these are the brief remarks I wanted to make. Thank you, Chairman.
Muy bien, muchas gracias.
Very well. Thank you very much. Over to Mr. Rodriguez Recia.
Yes, micrófono.
Thank you, Chair. Thank you to the rapporteurs for having presented us this project. I'm reading the Spanish draft, and I believe that if we simplify things a little, particularly in the first paragraph, it would be much clearer. And I would also like to make a observation on the topic of list. Although they may be used for examples, they are categories of different examples of deprivation of life. In the first part of the first paragraph, we've said that this focus is on the state's responsibility, and so we're going to analyze life not as a criminal right, but as an objective responsibility of the state, which means that an act of state or an omission of the state, or an omission that can be due to the state. So I would suggest that the problem is speaking of deliberate acts in the first paragraph, because by not excluding emissions, we need to be a little more specific. So I would propose the following wording, if you allow me. Deprivation of life is a deliberate act or an emission which is due to the state, which is foreseeable or avoidable, and which leads to loss of life and aims to inflict damage or wounds that may lead to loss of life, because there we're looking at the intention as well, which is covered by criminal law. And so the two state acts, positive acts due to the state's responsibility, which could lead to a loss of life. As to opening up lists, although they might not be exhaustive, they could lead to death via road traffic accident. This could lead us to think of other cases of death which are not included. Why not put workplace accident deaths? I know that this is a list to give examples, but I don't know in which way it helps us. For example, opening a debate on euthanasia, which is allowed in some countries. And we have not significantly debated whether this is a violation of the covenant or not. The same with assisted death. And so I would be prepared to set out lists, or rather ask whether these lists raise a debate or issues that we cannot resolve or we haven't resolved. This is what this could lead to. So I believe that we should simplify this paragraph in the way in which I have proposed. Thank you.
Muchas gracias, señor Rodríguez.
Thank you, Mr. Rodriguez. I have 4 more speakers on the list. Mr. Iwasawa.
Thank you, Mr. Chairperson. I have 2 points, and I will try to be brief. I have an impression that this draft often goes beyond what the life means in Article 6 and goes into existence in a social security sense. I don't think that the existence in the social security sense is not covered by the term life. So I have a concern with regard to the first sentence at the end, the term standard of living. I think I propose to simply to say that goes beyond mere damage to health or bodily integrity. The second point is the last sentence. I agree with the proposal made by Mr. Sitosin. I think it's a good proposal. At the end, it should say that may result in loss of life. Thank you very much, Mr. Chair.
Muchas gracias.
Thank you very much. Miss Cleveland. Miss Cleveland, rather, sorry.
Thank you, Mr. Chair, and I would like to thank the rapporteurs for their ongoing work on this excellent draft. I welcome my location in the queue because what I was planning to say has been said at this point largely by others. I would simply like to endorse the point made by Ms. Seibert-Fohr about better clarifying between the negative and positive obligations of states in this regard. And I think that Mr. Satulsing's proposed rewrite of the last sentence goes towards accomplishing that by helping to articulate the positive side of these obligations. With respect to lists, I don't object to the idea of including lists. I think that if we include examples, we should make clear when we are giving examples of situations where the state has actively deprived life, negative obligations, versus where it has positive obligations to protect. But regardless, with respect to the lists that are the examples that are presently there, I would recommend that we delete the last 3 examples, assisted suicide, euthanasia, and infanticide, in part for the reasons expressed by Mr. Rodriguez-Recia. And I don't think that they're necessarily the examples that we want to highlight in the very beginning of the general comment. There are many others. Thank you.
Muchas gracias.
Thank you very much. Mr. Busid?
شكرا سيد الرئيس. سيد الرئيس أنا لي سؤال
Thank you, Chair. I would like to ask a question to the rapporteurs. As regards deprivation of the right to life, what about famine? Widespread famine, pandemic diseases, these are some of the many manifestations that affect the right to life. And even deprivation of the enjoyment of the right. In this cases, the state, perhaps with international community assistance, should shoulder some responsibilities each time there are such cases, which could lead to the deprivation of enjoyment of the right to life because of famine or similar causes. Thank you.
Muchas gracias, señor.
Thank you very much. Mr. Vardalashvili?
Thank you very much, Chair. I'll try to be brief. I also like to thank the rapporteurs for their ongoing effort. Just very few points. First, I would also support the proposal to focus on and distinguish between the positive and negative obligations of the states with regard to the right of life. With regard to the last sentence, I think which may create some confusion about regarding the scope of this article and whether it includes some obligations of the state in providing the social guarantees or social security. I think that, as Mr. De Freville proposed, I think that adding some examples would help here, because we indeed require from the state parties to act accordingly and adequately when there is a genuine threat to life, which may result in loss of life, and some maybe reference to some cases as well as to the examples would help. Thank you very much.
Muy bien, muchas.
Thank you very much. I will now give the floor back to the rapporteurs so that they may react to our colleagues' comments. Mr. Shaney.
Okay, thank you. The way we are going to do this is that we are not going to address specific suggestions for formulations, but I will try to answer questions and maybe share some thoughts. And because we want to reflect upon the comments, and then on the basis of the comments come back to the committee with a new draft. Just to make first perhaps an initial observation, and that is that we have to remember that this is just one paragraph out of many paragraphs. So a lot of the issues and the specific questions that have been raised are addressed subsequently. So for instance, examples. There are many examples in subsequent paragraphs with regard to positive obligations by the state in a variety. And I don't think we can cram everything within this initial paragraph. There is a question of interpretation here on what is the distinction between deprivation of life and the duty to protect life. And there are two schools of thought here. One is that deprivation involves an infliction of harm either by the state or by a non-state actor. And on top of that, the state has a duty to protect life both from non-state actors but also from natural phenomena such as famine, for instance. But one could also take a different approach and have a broader understanding of what deprivation means. This is something on which guidance by the committee could be useful. My own position is that the term deprivation does connote a certain act, either by the state or by an individual, and that the state's obligation are geared, the positive obligation by the state are geared towards protecting individuals from harms by individuals and also by harms generated by other causes. But this is something that can be discussed. This is also in response to Mr. Politi's point. Mr. De Freville asked about thought. I don't think that the idea here is about thought. The idea here is about state responsibility, however. We are requiring state to address deliberate harms, foreseeable harms, and preventable harms. We are not requiring state to address other harms, which are neither deliberate, foreseeable, or preventable. This may indicate some degree of fault, but not in the criminal law sense of the word. There have been a number of very useful suggestions, and we will have to consider them on whether to draw a sharper distinction between positive and negative obligations by the state. Many of the language proposals proposed formulations seem very acceptable. I will perhaps just say one final point, and then perhaps Sir Nigel would want to come in, and that is with regard to the may. Why did we, in the last sentence, why does it read, may require state parties to address threats of life? And that is precisely because of the question of the obligation of the state is a due diligence obligation. So there could be certain life-threatening harms which the state, under international law, would not be required to address because they are not deliberate, they're not preventable, they're not foreseeable. So that was why a more cautious term was used. Maybe just one more point that Mr. de Froville raised, and I think is an important point about delineation, different rights. And of course, Mr. de Froville is right. I mean, the same violation, as the same act by a state or by a private actor could simultaneously infringe both Article 6 and other rights. I think the point that we were trying to make, but that there is a certain area in which the violation would be only of Article 6 and would not be, for instance, the right to health issues. So let me put things differently. Not every violation of the right to health would automatically also constitute a violation of the right to life, for instance. So there is some area in which we can distinguish, but that doesn't mean that there is not a significant area of overlap between the two. Thank you.
Muchas gracias.
Thank you very much, Sir Nigel.
Thank you, sir. I have very little to add other than that I was surprised to find that that intentional deprivation of life situations were more in the realm of criminal law and didn't necessarily belong in a human rights document, or at least that's what I understood Mr. Froville to be saying. And of course, the question of deprivation of life is the most central aspect of arbitrary deprivation of life is the most central aspect of Article 6 and has to remain that. Not only the most central, the most important. Most of our work has been involved with issues relating to extralegal and extrajudicial killings, arbitrary and summary executions, and so on. That's where most of our case law is. That's where we have the most respected jurisprudence. And I'd find it difficult to accept any suggestion that somehow we have to have some kind of equal balance between deprivation and protection. That said, I do take on board the observations of Mr. de Froville and numerous other colleagues that some clearer distinction between the positive and the negative might help clarification here and avoid some of what may have been misunderstandings flowing from the text as it's drafted at the moment. Given the various examples that colleagues raised, either to include or exclude, I had, if we have a list, I was expecting somebody to mention deaths from gun violence, which might figure quite as highly as deaths from road traffic accidents. And if we do work on, if we do maintain a list, and that, of course, we have developed a practice on dealing with that issue, and it would be a shame not to recognize it. Even though I'm a rapporteur, I failed to remember to put that particular element in. As I say, if we decide we do maintain examples, colleagues should expect to find that one added in the next draft before them. Thank you very much, sir.
Muy bien.
Very well, thank you very much. Mr. Politi.
Again, just to thank colleagues, obviously, and the rapporteurs for their explanation. It may be true that that the following paragraphs would shed light on some of our doubts, but still, this paragraph is central in the context of the general comment. Also, it's important to get it right. On the point that I raised concerning infliction and a concept of omissions, which leads also to the issue of positive and negative obligations of the state. I didn't have time to put it down, but the suggestion by Mr. Rodriguez-Recia seemed to be at least interesting to explore, to see whether that does the trick, as I can say. On the question of examples, it's always difficult to have examples that are dealing with all the issues that we want to address. For example, I haven't talked about gun violence, but now I'm stand to be convinced that it's something that should be addressed probably if we have a list of examples. But I want to add that if we accede to the idea of referring to acts of omissions, to omissions by state, we should think about the example of denial of life-sustaining goods and services, including food, water, sanitation, and shelter, or something along these lines. We cannot provide examples also on one part of what the article intends to cover. I took the floor also to support Mr. Sittelsin's suggestion with regard to the penultimate sentence of the paragraph, and everybody is in agreement in deleting still in the last sentence. This is fine, although I didn't understand really the concept of address threats. Maybe at some point we should think a little bit, what does that mean? Address it in legislation, in criminal legislation, in providing some sort of social security measures, perhaps saying very generally is the way not to get into too much specific examples, but I'm trying to understand what address means really. Thank you.
Muchas gracias.
Thank you very much. Mr. Benachur. I would just like to ask our colleague, Mr. Fourville, if he could explain this distinction that he makes between those acts that fall under international criminal law and those that fall under human rights. If he could explain that distinction to us, that would be wonderful. My second issue is the distinction between positive and negative responsibilities on the parts of states. We must make sure that we do not overload the text, because the idea of positive and negative responsibilities is not spoken about in just one paragraph afterwards, but in several. For example, paragraph 12. States parties have the duty to respect the right to life, so that's positive, and refrain from engaging in conduct resulting in deprivation of life, and that's negative. So here I believe that we need to be careful not to repeat the same ideas that come up later in the text. As Mr. Chani said, we need to take the text as a whole. That's all I wanted to say. But I would also like to add that I would like an explanation from Mr. Fourville between this criminal law and human rights. Thank you.
Muy bien, muchas gracias.
Very well, thank you very much. I will now give the floor to Mr. Fourville.
Monsieur le Président.
Thank you, Chair. Upon reflection, and after having heard my colleagues and also explanations given by Mr. Cheney and Sir Nigel, I believe that one of the difficulties in this text is that we're not particularly sure if we're tackling states' obligations, positive and negative obligations, obligations to protect rights or law or to respect it, or if we're looking at situations which are covered by Article 6. And here, when I talk about situations, I'm talking about things that happen, events. So I believe that there's some ambiguity here. We seem to be skipping from one to another. This gives us an impression of confusion, which may in part explain our discussions, I believe. So, to answer Mr. Benachur, if we speak of the obligation of the state in international law and violations of international law on the parts of the state in terms of their international responsibilities, in no case are we seeking to look at the state's intention. There's an omission. It's an internationally illegal act, which could be either an act directly or an omission. But the fact is that it's illegal. The International Law Commission did not exclude the issue of fault. This is not key in determining the facts. So, when we speak about acts or omissions that could fall under the state's responsibility, then we need to leave out any language relating to intention or fault. If we're speaking about facts or events, and here I agree with Mr. Cheney, if we're speaking strictly of this, then I can understand a little better. Indeed, we could say that Article 6 only covers facts or events which are the deliberate, foreseeable, or avoidable. I believe that's what Mr. Cheney wanted to say. However, the difficulty lies in the fact that after that, we have the impression that we're heading into language of responsibility with the term damage, because damage, it really comes back to responsibility, or rather harm. So we speak of harm and damages, and therefore reparations. And so here we're speaking of responsibility. So I believe that there is slight ambiguity here. So my response would be that, in terms of international criminal law, clearly we speak about intentions, general, specific, or otherwise. But in general, in international criminal law, we do not speak of intention. Here, we can speak of intention, but we need to be clear. Perhaps to answer Sir Nigel on the primary characteristic of deprivation of life as regards to the risk aspect, I would remind you of paragraph 5 of General Observation number 6, which is the foundation. We mustn't forget that this is the foundation that we are building on. This comment said that it was too often narrowly interpreted. The right to life cannot be understood restrictively. The protection of this right requires states to adopt positive measures. In this regard, the committee believes that it would be desirable for states parties to take all possible measures to reduce infant mortality and to increase life expectancy, particularly measures allowing us to limit malnutrition and epidemics. So that was in 1982. That was committee in 1982. And there are many paragraphs that take this idea back up. So I don't believe that we've established a kind of hierarchy. I believe that it's entirely relevant. I therefore believe that this should be further highlighted in this paragraph. Thank you.
Muy bien.
Very well. Thank you very much indeed. Before giving the floor to the rapporteurs, I think we all agree that it's a matter of objective responsibility of the state by act or by omission. Perhaps the problem surrounds the word deliberate. I don't think we ought to dwell unduly on whether we are looking at human rights, international law, or criminal law objectively. Clearly, it's a matter of state responsibility, and I hope the rapporteurs understand that. If we are going to put examples in, we need to ensure that they chime with our concluding observations, indeed. We do not want to include examples that run counter to what we have said in previous general comments and concluding observations. We have heard references also to economic, social and cultural rights, and here I think that the committee has been lacking in its findings to date. We've never said that the rights are indivisible. Other committees have, but we have not yet done so. And I think, therefore, that we should look at that possible interrelationship between the categories of rights. I dare say the rapporteurs will take into account our opinions and come back to us with a revised text. We are not here as an 18-person drafting committee. That would be unworkable. We couldn't simply work like that as a committee of the whole. I would like to give the floor back at this stage to the rapporteurs, Mr. Shani and Sir Nigel.
Thanks. I don't think the further discussion requires any specific response from us. When you're ready, we can move on to the next paragraph if you feel so inclined, sir.
Sí, muchas gracias.
Thank you very much, Sir Nigel. No, I simply wanted to give you the floor if you wanted to add anything as rapporteur, as is proper. But if not, let's move on to the next paragraph. Paragraph 7. The rapporteurs have the floor again.
Thank you, sir. This paragraph, I suppose, is self-explanatory. The committee has developed a depressingly extensive familiarity with the atrocious phenomenon of the enforced disappearance. Obviously, as we indicated in General Comment 35, the central, from our perspective, because the Covenant doesn't refer to disappearances anywhere, so it's a question of the interrelationship of various articles. The central one, violated obviously in its most flagrant way, is Article 9, liberty and security of person, prohibition of arbitrary arrest and detention. But, as indicated in this paragraph, there is typically a right to life dimension to it. In fact, very sadly, probably the overwhelming majority of disappearances, as we've come to understand them, do indeed result in deprivation of life when the information eventually comes out. Though, of course, presumption of death is absolutely not the function of this or any other human rights body. One always has to maintain the principle that people who are the victims of enforced disappearances have a right to expect the reappearance alive of their loved ones, which is why we use the language here as being a violation of the right to life or a grave threat to thereto, because one doesn't want to imply that life has necessarily been the deprivation of life has necessarily been the result of enforced disappearance. So that's what the paragraph is about. Look forward to hearing and taking on board the comments of colleagues. Thank you, sir.
Muchísimas gracias.
Thank you very much, Mr. Shani.
Yes, let me just add that this segment, which actually we now enter into, which includes paragraph 7, but also paragraph 8, 9, and 10, they deal with questions relating broadly with the scope of Article 6 and its relevance to some of the more recurrent issues that have been raised before the committee. At least the two first paragraphs deal with issues that the committee has been dealing with quite extensively, either in the periodic reports or in the individual cases. And the plan is here to underscore the role that the right to life plays in addressing these situations. Thank you.
Muy bien, muchas gracias.
Thank you very much indeed. I'd like to open the floor for comments. Mr. Benachur, please. I just had a question to the rapporteurs. In paragraph 7, the word disappearances has been used 3 times without the adjective enforced. Did you choose to refer to disappearances deliberately as opposed to enforced? What was the thinking behind that? Because on the 3 occasions we simply have disappearances, no enforced. Thank you.
Muy bien, muchas gracias.
Thank you very much. Mr. de Frouville?
Merci beaucoup.
Thank you, Chairman. And my thanks to the rapporteurs for this proposed language. I have a number of comments on this paragraph. Let's start with the first sentence. Broadly, I agree with the second part of the paragraph. Paragraph 6 is the speaker. Even though there are some important points with regard to the right to life that could be added, but it's particularly the first sentence that is problematic for me. Apparently it derives from the committee's jurisprudence, but when one looks at it a little more carefully, it's not quite as simple as that. It's already, it seems, an interpretation of the committee's jurisprudence. In the English version, we see, after the first sentence, the citation of the Saker case. This is quite an old case, and which doesn't say exactly the same thing. I have a more recent case which takes up this jurisprudence also and states something slightly different. And I will quote it to you now. It's the Katwal versus Nepal case. The committee considers that even if the expression enforced disappearance does not specifically appear in any article of the Covenant, enforced disappearance constitutes a single set of continued violation of a series of rights which are enshrined in the Covenant. And this is the content of that Katwal versus Nepal case. What changes here vis-à-vis the previous case is the reference to the non-inclusion of enforced disappearance in the Covenant. We can skip over that, but what we do see in the text, however, is the fact or the notion that enforced disappearance constitutes a set of acts and omissions which is indivisible. But I think what does change here in the Katwan case is in this draft paragraph is that we are talking about acts or omissions intended to, the intended to, which we do not see either in Saker or in Katwal, in the committee's jurisprudence. And in fact, that poses a problem, given that it introduces an element of intentionality. I come back to my point on intention. Here we have intention being included in the definition of enforced disappearance. And rather than describing enforced disappearance, which would be an appropriate thing to do here, it seems to be offering a definition of enforced disappearance. I do not think, however, that that is something we should engage in here, unless we are to repeat the definition which today is the authoritative one, i.e. that given by the Convention on Enforced Disappearance of 2006, Article 2 and possibly also Article 3. I do not think we should go giving definitions of enforced disappearance. That's not the point here. We should describe what enforced disappearance is and what it represents vis-à-vis the obligations under the covenant. And here, I think the wording from the Catwell case is appropriate. Here we have a single, indivisible set of acts and omissions which constitute violations of rights enshrined under the covenant. There's no reference to intention to remove an individual from the protection of the law. That is not included in that jurisprudence. And I think that jurisprudence ought to be reproduced verbatim here. If there's no reference to the right to life, that can be added. The speaker has... Right. In a series of communications, for example, the Awali case, 2013, or the Jebashirub case, we have a list of findings where, and I quote, the committee recalls that with regard to enforced disappearance, the deprivation of liberty following denial of a failure to acknowledge that, and the deliberate hiding of that person removes that person from the protection of law and leads to a constant threat to life for which the state holds responsibility. And if we take up the text from that citation following the Catwell citation, I think we will really get to the nub of the relationship between enforced disappearance and the right to life. In other words, the violation through enforced disappearance of the number of rights under the covenant, which leads to a constant threat to life. And the placing in a dangerous situation of an individual through enforced disappearance. As for the rest of the paragraph, I can essentially go along with it. I would stress that we are not a drafting committee. I wouldn't want to go into editorial matters. For the remainder of the paragraph, essentially, I find it clear in terms of what states parties are called upon to do, take measures to prevent the disappearance of individuals with a view to minimizing the adverse effects on the right to life. I think we do address the problem, very much so. That said, I think there might be questions that have been overlooked in the drafting and could be added. And these are points that have been made, for example, in the committee's concluding observations and also in various communications with regard to death certificates and more specifically the enforced or the obligation by a state of acknowledgement of death of a person in order to receive a death certificate, and the obligation by the state on a family to have a death certificate issued. I think there's a very clear link both with Article 7 and 6, because when it comes down to it, the victims are being forced to do exactly what we are trying to avoid in our jurisprudence, and I think that merits clarification with a textual explanation of the committee's jurisprudence. I think the committee has always sought to show that if there is an alleged violation of Article 6 as part of an enforced disappearance that is not elucidated, in other words, the person's remains have not been found, the finding of a violation of Article 6 does not mean that the individual has died. That is a very important point for the families of the disappeared. They do not want to be told that their relative has died. They want to be brought back alive. That's the plea we hear from families. They refuse to admit the death of their loved ones until they have proof. So, finding a violation of Article 6 does not mean a finding of death. Similarly, imposing a death certificate on a family means that the state is basically obliging them to accept the death of their loved one, and I think that poses problems vis-à-vis Article 6. Beyond that, the Working Group on Enforced Disappearance, but also the Committee on Enforced Disappearance, has come up with various guidelines. The same goes for the ICRC. These guidelines are designed to help states move away from this system of death certificates. It encourages them to implement a mechanism of presumption, which enables various legal difficulties to be dealt with throughout the period of the disappeared person's absence, without forcing the family to recognise death of the individual. The presumed death is a suspensive document, if you will, which enables the legal situation to be dealt with. So we might perhaps be able to enrich the general comment by including such considerations. This could be something that could be scaled up gradually on a progressive basis, because as far as I know, the committee has not yet specifically dealt with this issue, but other bodies have. Is the committee going to follow those bodies? I think that might be something to leave in the hands of the rapporteurs. Thank you, Chairman.
Muchas gracias.
Thank you very much. Mr. Rodriguez-Recia, please.
Gracias, Presidente.
Thank you, Chairman. I sought the floor when Mr. de Fruvel was speaking, and I think it will be difficult to follow on from our local expert on the issue of enforced disappearance and rights, but I'll start here. I would endorse what Mr. Benachur said. The use of disappearance generically without the use of the adjective enforced has meant that some states have ended up using phrases such as non-located persons. Let's be clear, we're talking about enforced disappearance, where a state has been involved in an act or omission that facilitates the emergence of this situation of disappearance. I'm having difficulty also with unique and integral, and also the fact that since March last year, jurisprudence has existed within the committee of an enforced disappearance leading to a violation of other rights under the covenant. That needs to be borne in mind, and bearing that in mind, I have questions in my mind as to whether the intention to remove an individual from the protection of law is a consequence or a cause. It's possible that there might be other intentions behind the removal from the protection of the law. There might have been torture, there might have been illegal detention. I do not think we can necessarily take the integral series of acts as an indivisible unit. I think there's a need for more clarity on that point. The second part states that state parties must take adequate measures to prevent the disappearance of individuals. Enforce is missing here. The key point is to prevent, but beyond that, there's a need to very clearly prohibit, and I would suggest the addition of prohibit and prevent in that order. And very importantly, the following language with regard to protection and investigation. Habeas corpus, or words to that effect, with a rapid system to locate the whereabouts of the person, find their remains. The investigation is a sui generis consideration, but if we're talking about habeas corpus, there needs to be some kind of swift, simple, urgent, straightforward protection system in order to ensure that the person can be sought out. As Mr. de Frouville said, enforced disappearance may be temporary, but in that lapse of time, the individual may be alive, and that is the time when it is absolutely essential that this rapid mechanism of protection can be implemented. This is why I make reference to the habeas corpus notion. I would be reluctant to mention habeas corpus as such because of the potential ramifications of that term, but there's a need, I think, to bear in mind this response, i.e. an urgent way to find the body of the individual, alive or dead. Thank you, sir.
Señor Fatala.
Mr. Fatala, please.
Mr. Chairman, again. Mr. Chairman, I have 2 or 3 comments on this paragraph. The third one, that I will not object to speak about the disappearance, but I prefer, as it was stated, to speak about forced disappearance, because we are not speaking about just disappearance. Second, this paragraph, this issue of disappearance, for me, is more linked to Article 9, which speaks about to deprive the person from liberty. Although this is, I'm saying that, I don't mind to link it to Article 6 dealing with right to life, but here we should link it only to the issue of threat to life and not to the right to life, because we don't know that the end result of the enforced disappearance will be related to the right to life as a whole, but it is a threat to the life. Therefore, I prefer to focus on this, that it is a threat to life. It is an enforced disappearing which is related to the threat to life, and I think that also this can go along with what was mentioned with Monsieur de Prouville, that what about the family, the psychologically, they don't want to know, speak about right to life if they are not sure that whoever from the family has disappeared and so on. Therefore, we should focus on threat to life.
Muy bien, muchas gracias.
Thank you very much. Mr. Politi, please.
Can be relatively brief. Many of my concerns have been already raised by colleagues, in particular Mr. de Frouville and Mr. Rodriguez Recia. Some of colleagues will recall that when we discuss in general the draft comment, I was asking colleagues whether the paragraph on disappearance or enforced disappearance could not go somewhere else together with other paragraphs. For example, now 22, 25, and 60. But I would not insist on this. I don't want to make the life, especially of the rapporteurs, too difficult. But maybe they can give a little consideration to this if they think that that is fit. So for the rest, I can be, as I said, really brief. Enforced disappearances, I think that the concept of intended should be corrected, maybe with something that in French is visant, in English perhaps aimed at, something like that would help in the drafting. If we say an integral series of acts and omissions aimed at removing an individual and result in a flagrant violation. It's just a drafting suggestion, but very, very quick, and the rapporteurs can take care of it. Instead, I think that reducing in the last sentence the aim of the investigation through an independent and impartial procedure to minimizing the adverse effect on the right to life is a little too little, if I can say that. I think that we should, as Mr. Rodriguez Recia, I think, suggested, we should add elements such as establishing the fate of the disappeared, bring the perpetrator to justice, and provide reparations for the victims of the crime. I don't think this is going too much in detail. These are elements that are essential in our case. So I think we should add to the concept of minimizing the adverse effect of the right to life these elements that are strictly connected with the duty to investigate properly
gracias.
Thank you. Ms. Cleveland, please.
Thank you, Mr. Chairperson. I had also asked for the floor primarily to make the point that Mr. Politi just made, which was that my initial reaction to the paragraph was that it wasn't entirely clear to me why disappearance was this soon in the draft, and also that it ought to that we ought to try to combine or collect all the various issues that we address with respect to disappearance in one location in this general comment. Right now they tend to be scattered through the general comment, and I think that the points made by Mr. de Fruville and Mr. Rodriguez-Recia also underscore the fact that we have a quite elaborate and long-standing jurisprudence with respect to disappearance that implicates a number of different issues. So I would like to see a more fully developed treatment of our disappearance jurisprudence collected in one place, possibly later in the draft than it is right now. Thank you.
Muy bien, muchas gracias.
Thank you very much indeed. I will take the liberty to speak in a personal capacity. Since we're in public session and various points have been made, I would like to indicate that the committee in its jurisprudence has evolved over time in terms of its coverage of enforced disappearance, and the violation of the right to life found does not mean necessarily that the person is deceased. Therefore, in terms of redress, we call upon the person to be found recovered alive. There is a violation of Article 6, but also, at the same time, we are not implying a presumption of the death of the individual. Since that jurisprudence was established, there's been no protest from family members, because the committee has never suggested that the person's death was to be presumed. I echo much of what has been said. I might make a suggestion of an addition after constituting a grave threat. I would add the following: implying a violation of the duty to guarantee the right to life. This would bring us into line with our jurisprudence on this matter. And this is what I wanted to say at this point in a personal capacity. At this point, I will give the floor back to the rapporteurs to hear their reactions to colleagues' comments. Sir Nigel?
Thank you very much, sir, and thanks to the colleagues for all their comments. I think this is a less problematic issue. I think it is right that we move the paragraph, that we pull it together as suggested by Ms. Cleveland. I actually think that Mr. Politi's suggestion, I'd forgotten he'd made it at the general point, because if I'd retained it, the suggestion, I would have even started with that. I think it probably figures best precisely in the chapter which deals with the relationship between Article 6 and other rights. And that also would help meet Mr. Fatala's point. It doesn't mean that I'm going to force colleagues to wait till 2024 before we get another look at it. I'll try and bring a draft back. We'll try and bring a draft back to the committee before the end of this session, but with a view to its being relocated. The omission of the word enforced is total oversight, and I apologize to colleagues for that. It's sloppy. I was used in my days at Amnesty to refer to disappearances in quotation marks, precisely to distinguish them from the notion of missing persons. I dropped the quotation marks and omitted to put in their place the necessary adjective, which is the standard adjective used by the working group and indeed the Convention against Enforced Disappearances. So just apologies for that, and certainly no intention to change anything there. In fact, there's been no intention to change any jurisprudence. I do hope colleagues won't keep making the point that we've cited something in a footnote that doesn't capture everything that we've said. I'd prefer to go straight to the issues rather than a discussion of our jurisprudence, unless there is some indication of an intention to vary jurisprudence. While I'm not clear what the problems with the words unique and integral are, I take the points made by colleagues and shall certainly try and take them on board. The various points made by colleagues about locating the remains, some fast form of habeas corpus, tutela, whatever, amparo, is going to be important, and as indeed was the case in General Comment 35. I do think colleagues should not expect us to make this a general comment on enforced disappearances. It's a general comment on the right to life. We may not be able to, getting the balance right, to include everything that everybody would like to see. Just one issue of substance that and maybe I didn't understand, but I thought I heard Monsieur de Frouville talking about inviting the state to make a presumption of death. We don't do it ourselves, but we invite the state to. And if I did hear that correctly, I would have great difficulty following it for the reason suggested by Mr. Salvioli. I remember when the Argentinian junta did precisely that. After a period of years, it legislated that there would be a presumption of death, and the families then could get on with their lives. And the reaction with the families was, presumption of death is absolutely intolerable. They're not prepared to presume death, and they're not prepared to let the state presume death. But maybe I misunderstood the point he was making. But if that was the point, then I guess I wouldn't be able to take it on board. But other than that, I'm grateful for all his and other colleagues' comments, and hope we can come back with a text that will meet most people's concerns. Thank you, sir.
Muy bien.
Thank you very much. I would simply like to say a word on this last aspect, which is that in some countries this issue of certificates has been solved. They've done so by setting out or establishing a certificate of absence due to enforced disappearance. Not absence because of presumption of death, but absence because of enforced disappearance. And so this allows them to proceed in the legal process, civil issues, for example, because in some aspects of civil life you may well need this certificate. Mr. de Frouville, would you like to take the floor? You have the floor.
Si c'est possible, je sais pas.
If it's possible. I don't know, because we have a second issue to address. Thank you, Chair. I would just like to give you two clarifications on the last point that was tackled by Sir Nigel. I believe he misunderstood me. I was making a distinction between the death certificate and the presumption of death. So those are two very different issues. The certificate of death is a certificate that certifies to the death of a person, whereas the certificate of presumption of death is a presumption of death, and in some countries which do not have a certificate of absence due to enforced disappearance, some countries have set this up, but not all. So in countries which do not have this ideal certificate, the certificate of presumption of death allows us to address a certain number of issues, for example, childcare, managing of assets, and beyond other legal measures. Without this presumption of death, you are in no man's land. In some countries, the tragedy of enforced disappearance is the suffering due to the absence on the part of the family, but also the fact that all of the civil issues are in no man's land. For example, the wife of the person who has been disappeared has no right over his assets because officially the person is not dead. So often families are required to or forced to ask for a death certificate in order to manage all of these issues, particularly for childcare, for example. Presumption of death, which is the mechanism recommended by the ICRC for their model on missing persons, but also their work on enforced disappearances, allows us to solve this issue. And then a last point on intentionality. I would really like to underscore this once again because I heard the proposal of Mr. Politi, but I don't think it entirely solves the issues. There's really a difficulty here. I know this is a text that is very dear to Mr. Politi. The Rome Statutes, obviously not for the content. And from the outset, this definition was criticized because the definition of enforced disappearance in the Statute of Rome was criticized exactly because it included intentionality. The intention of removing the person from the protection of law for a prolonged period. And so this means that today prosecutors in international law have serious problems because this is a crime which is almost impossible to categorize in reality. And it also has absolutely no link to the definition of enforced disappearances under international human rights law, which does not look at intentionality. It suffices to see that the person has been removed from the protection of law, and that's the end of it. So I believe that we need to remove this issue of intentionality because this does not appear in our jurisprudence. And so we will be muddling our jurisprudence with issues that should not fall within it and which complicate the definition of enforced disappearance. Thank you.
Bien. Muchas gracias.
Thank you very much. I would like to use the time as best as possible. So if you would allow me, I would now like to move forward. But Mr. Fatala had asked for the floor, so I will give it to him. Over to you.
Chairman, very quickly, because I need a reply to the issue I raised. I raised the issue that we should focus on this threat of life. And if the two rapporteurs wants to have a concrete proposal, I would just say that we can say that it constitutes a threat to life, and therefore a violation of the right to life, because the focus, it is a threat which can lead or which is a violation of the right to life. And then we focus first that it is a threat to life and therefore a violation of the right to life. Not to go to the end result that it is already a violation. It's a threat and therefore a violation to the right to life. Thank you, Mr. Chair.
Muy bien.
Thank you very much. I'd made a suggestion for drafting that followed along the same lines. The rapporteurs will surely take these ideas into account. So, very well. Let's continue. So we'll move on to paragraph 8.
Señor Shani.
Mr. Shani.
Thank you. Just on 7, I didn't want to take time, but Mr. de Fruville, just to respond to Mr. de Fruville, the Sacker case, which is cited, does refer to the Rome Statute. Now, we can decide not to follow this, but it was at least 10 years ago, this was the jurisprudence, and it may have shifted, and I have no issue with changing it. I just wanted for the record that it was not an invented concept. Moving on to paragraph 8. Paragraph 8, I think, would fall, like paragraph 7, in the category of a paragraph which deals with a specific, very important, those specific issue concerning the right to life. We may decide, like we may decide with respect to paragraph 7, in the end, not to locate it in the opening segment, but rather further down the paragraph. This is something that will be discussed. This paragraph has already been, I should say, dealt with, discussed to some extent in a joint meeting that the committee has held with the CEDAW committee last session. We have also had the chance to reflect on this when discussing some other business of the committee, the concluding observations and also communications. There have also been some consultations with officers in the office who have submitted comments. So what you are seeing here, the text that was distributed, is already slightly different from the initial text that was circulated. As currently the text reads, there would be a question, there is a proposition regarding the applicability of Article 6, namely whether Article 6 protects the right to life of the fetus. And this is an issue that already informally some colleagues have expressed doubts as to whether this should remain in the text. Then there are the circumstances under which the duty to protect the life of women would require states to provide for safe abortion. There is also allusion to the case law of the committee in this regard with regard to some other exceptions that are closely associated with Article 6 or Article 7. The second half of the paragraph deals with the problem of unsafe clandestine abortion and does require on states to take certain measures to minimize that problem, and more generally to refrain from introducing burdensome or humiliating requirement for seeking abortion, and to provide information and access to certain reproductive options and facilities and prenatal health care, again in order to protect life of women. So I suspect we would not finish within 15 minutes dealing with the issue comprehensively, but it would be useful to start getting from colleagues comments on this issue.
Muy bien.
Thank you very much. Sir Nigel, you wanted to add something? No? Point of order, Ms. Cleveland.
Thank you, Mr. Chairperson, and thank you to the rapporteurs for the introduction. I expect many members of the committee may have general reactions to this paragraph as well as specific textual ones, and it wasn't clear to me whether we should divide the conversation so that we get general reactions and then later textual ones, or if it seems complicated to mush it all together.
Sí, muchas gracias.
Thank you very much. We're going to have a general debate on this paragraph, and then later on we'll take specific proposals. Mr. Seetal Singh.
Thank you, Chairman. Actually, I wanted to raise the same kind of point, but I must say that I welcome what Mr. Shani has said as to whether this paragraph should be moved down. Now, this is an important decision. If we decide to move the paragraph down, then I believe we should take this decision right away, or else we are going to embark into a long discussion concerning this paragraph and then decide whether to move it down. I say so because we are still in the context of general remarks, and general remarks are giving rise to a lot of debate. And in paragraph 8, we start with a negative proposition because we are looking at the scope of these general comments. And we start saying right away that the covenant does not explicitly refer to the rights of the fetus, which is which for many people is a debatable proposition, although the word fetus is not mentioned. We know that in Article 6.5, and again, this is not, there's no general agreement about this, but is Article 6.5 referring to the rights of the unborn child? I know we don't agree on this, but in the travaux préparatoires, it is said that the principal reason for providing in Article 6.5, which was then paragraph 4 of the original text, that the death sentence should not be carried out on pregnant women, was to save the life of an unborn child. Now, this again, as I've said, may give rise to a long debate. And we find again that when we start the second sentence of paragraph 8, and I must say I'm very grateful to the rapporteurs for having been able to condense in this paragraph a lot of debatable points, especially about concerning abortion, and this is something that must be for which they must be paid tribute. But still, we say in the second sentence, we start the sentence with still, and this still again may give rise to a lot of sparkling controversy because we are using the word still again, and then we continue. And then with a proviso, provided that such. And then we come to all the points concerning the duty to save life. And here we are referring mainly to the life of the mother. And what I would suggest is that this duty to protect this paragraph would be better dealt with in part 3 of the general comments, the duty to protect life, where we could go into all the concluding observations and general and views the committee has expressed before, and deal with this under the duty to protect life. And just one final point on this Article 6.5, as I've said, which gives rise to a lot of debate, is why is this Article 6.5 there? That is, it's not to protect the life of the mother, but to protect the life of, to protect a life, the life of the unborn child. And we know that in all the laws concerning abortion, that all these laws specify that abortion will not take place after a certain period of time, whether it is 10 weeks, 12 weeks, or 14 weeks, and that there is a general acceptance that at a certain point in time there is life. So, which is why I hesitate when we make a general statement to say that the covenant does not explicitly refer to the rights of the fetus. It doesn't mention the rights of the fetus, but there is something quite implicit in Article 6.5. So my suggestion is that we should perhaps take a decision as to whether we should discuss this whole paragraph 8 under the duty to protect life, not in the context of general remarks. Thank you, Chairman.
Thank you very much. Ms. Saiba-Four?
Thank you very much, Mr. Chairman. As a matter of general debate, I would like to make two observations over here. First of all, I would like to express also my objections to the first two sentences in the draft. Now, neither do I find them persuasive in the reasoning, nor do I find them persuasive in substance. I think that while it's true that the wording of the American Convention is different from the ICCPR, it's not possible to make a contrary argument. this regard, this would not be in line with the rules of interpretation under the Vienna Convention. Now, of course, we can now engage in a very lengthy discussion and debate on the issue whether Article 6 of the ICCPR applies to the unborn. But I expect this to be extremely controversial, as it is in the world more generally. Other human rights bodies, therefore, have opted to leave this kind of issue open, and this is an option which is also open to us. I would like to add here that I wonder what the purpose of the negative statement in this respect would be. After all, the very purpose of our undertaking here by elaborating on a general comment on Article 6 is to protect life to the highest possible degree, and not to elaborate on the limits of the right to life under Article 6. It would be disquieting if we would turn the opportunity to strengthen the right to life into an undertaking which focuses on its limits. I must admit that I found it disquieting that the draft, and I would like to emphasize that this is a preliminary draft, seems to focus more on the limits of the protection of life rather than on a comprehensive protection. I would also like to recall that the Convention on the Rights of the Child, in its preamble, also recognizes the special need for the protection of the child also before birth. So how could we then possibly say that Article 6 does not? I also wonder what happened to the committee's critical approach to abortion if it used as a method of contraception. This committee has asked states to take steps to eliminate the use of abortion as a method of contraception by inter alia, ensuring the provision of affordable contraception and introducing reproductive and sexual health education in school curricula. I was not able to find this line of reasoning in the current draft proposal. Therefore, in sum, I think that we should delete the first sentences altogether. And if we decide to leave open the question whether the unborn is entitled to the right to life, we should at least recognize that there is a legitimate state interest to protect the life of the fetus, as the European Court of Human Rights has done in the A, B, and C versus Ireland case. Now I turn to my second observation, which is about the focus of the entire paragraph. I would like to emphasize that it would be insufficient to merely delete the two first sentences, as I think that the remainder is clearly based on the understanding of the first two sentences, that the fetus does not enjoy the right to life. For example, the sentence asking states basically to decriminalize abortion irrespective of whether the life or health of the woman was at issue, whether she had been a victim of rape or incest, or whether there was a fatal fetal abnormality. Furthermore, I find the terminology of the entire paragraph to be unprecise and overcomprehensive. I will come back to this later on, but let me just give you an example. What are excessively burdensome requirements? What are humiliating requirements? And what is a lengthy mandatory waiting period? More generally, I was asking myself, where is the link of all these limitations to the protection of the right to life? And therefore, I would like to associate myself with the previous speaker, my colleague, Mr. Siltusing, in advocating to redraft the entire paragraph in order to focus on the right to life more essentially. Thank you.
Muchas gracias.
Thank you very much. I will now give the floor to Ms. Cleveland.
Thank you, Mr. Chairperson, and I would like to thank the rapporteurs for all their efforts with respect to this paragraph. As I indicated in my point of order, I have a number of specific comments about the text of the paragraph, but I wanted to limit myself this morning to my more general comments. As a threshold matter, I think that consistently since the committee began addressing Article 6 in the context of abortion, we have uniformly and consistently applied the right to life in the context of protecting the right to life of the woman. We have never addressed or engaged in a balancing act between the interests of a fetus and the right to life of the woman. We've exclusively addressed the question in terms of the right to life of the woman and the risk that states' imposition of criminalization and other burdensome restrictions on termination of pregnancy may pose to the woman because of the circumstance it creates, such that women resort to unhealthy, risky, unsafe, and clandestine abortions. We all know that unsafe abortion is the third leading cause in the world of maternal mortality. We also know that in states such as South Africa, where they have liberalized their abortion laws, the number of deaths per 1,000 have dropped dramatically in very few years as a result of the change in legal obstacles. So I think that the reason that this paragraph focuses on limitations imposed by states, a point Ms. Seibert made, is because it is those limitations imposed by states that put the lives of women at risk and have engaged the committee's concerns with respect to Article 6. With respect to Mr. Satul Singh's point about Article 6.5, I don't think one can understand the negotiating history of Article 6.5 as somehow recognizing or bestowing a freestanding protection on a fetus. What that provision does is recognize the interest of a pregnant woman in the fate of a wanted pregnancy and protect the autonomy of the woman in that context. And so I generally support the approach of this paragraph. I have noted previously to the rapporteurs I would remove the reference to the American Convention. Ms. Seibert referenced the Convention on the Rights of the Child. Our convention has different text, and we are obligated to address the text that we have before us. Thank you.
Muy bien.
Excellent. I have various people who have asked for the floor. And we do not have an awful lot of time, so let's move forwards, and then later on, of course, we'll continue with this debate. Mr. de Frueville.
Merci beaucoup, Monsieur le Président.
Thank you, Chairman. Once again, let me thank the rapporteurs for their extensive and quite complex proposals. Here we have a very laudable effort to grapple with a quite difficult situation. We have a number of issues, of course, which have been raised by colleagues, including the situation of this paragraph, its inclusion in this draft, and I will echo what Mr. Satul Singh has said on this point to save time. I think this text, as is the case for perhaps other paragraphs, is not best placed in this part of the general comment and might be better put in part 3 under protection. I, in fact, do not think that this text ought to address the scope of application of 6. That is not under consideration. In fact, this is an issue that has never really been explored by the committee, looking back at the committee's jurisprudence through its concluding observations, but also its findings since the very outset. The committee has essentially restricted itself on the issue of abortion to the issue of maternal mortality. That's the only issue that the committee has addressed through the lens of abortion in connection with Article 6, at least. There are, of course, other matters pertaining to, for example, the right to privacy, Article 17, and so on. But as far as Article 6 is concerned, the committee has focused on maternal mortality and on the cause and effect finding, which has very much been documented by international organizations and NGOs whereby in countries where there is a blanket ban on abortion or excessive limitations on the right to practice abortion, de jure or de facto, deriving from either law or social pressure, which prevent women from seeking abortion, in those cases, the rate of maternal mortality increases drastically, as Ms. Cleveland underscored. On the other hand, we have examples such as South Africa, which was mentioned, where we see that the liberalization of legislation can lead to a significant cut in maternal mortality. I think, therefore, here that we need to focus on what the committee has always focused on. We don't need to change course at this point, I don't think. We should focus on the protection of the rights of the woman, and as such, position this text, which shouldn't be in the introduction, in another part of the text and focus on those points. Focus on the fact, to the effect that annually 22 million abortions are practiced in risky conditions. Annually, these high-risk abortions lead to the deaths of 47,000 women. This is what we're about. And since we're engaged in general debate, it's not just a matter of opening up access to abortion on the basis of certain very strictly limited conditions, incest, rape, threat to the life of the mother, or fetal abnormality. Recently, debate took place, or has taken place in various countries, one in particular, and it has been clearly shown that curbing opportunities for seeking abortion on the basis of these 4 cases would lead to addressing only a very small number of the clandestine abortions that take place each year. Moreover, the Zika epidemic places this problem very much in the public eye in a particularly acute way in various Latin American countries, because we know that this virus doesn't necessarily give rise to the death of the fetus at birth, but can lead to severe difficulties and unfortunately short life of the newborn child. So I think we need to look at the issue from that point of view. Now, does this necessarily mean that abortion should become a form of contribution? No, certainly not. The committee has made its views known and has spoken against practices of selection, sex-based selection of the fetus, which is entirely unacceptable. It's for this reason that I believe that in this draft it's also important, albeit perhaps less strongly, to bear in mind the committee's call to decriminalise abortion, but also to permit state parties to take preventive steps, as well as engaging in education, for example, through the development of family planning and genetic healthcare services that would foster more widespread use of contraception. This would work in view of both Article 6 and 19. So, Chairman, we have various problems with regard to the article, various content problems, and I think if we are to achieve a useful outcome, we would be wise to focus on the core problem under Article 6, the very core problem under Article 6, and at the same time to heed the Human Rights Committee's jurisprudence as established since its very inception. Thank you.
Muchas gracias.
Thank you very much. I am going to allow one more statement, and at that point we will have to suspend debate to move into a further meeting. I dare say that this will come up again during our next consideration of the general comment. Mr. Fatala, please, you have the floor at this point.
I would like to subscribe to the logic made by Mrs. Zyberford and Mr. Situn Singh. I will not repeat the arguments, but I want to add 2 or 3 points. First of all, that the aim of this practice of having general comment is to develop the interpretation of the civil and political covenant, because it has been adopted 50 years ago, and therefore we should take into consideration all the development, including scientific development. And then when we speak about the right to life, we should also be aware what the science is doing concerning when the life starts and so on. And as we did, for instance, for when we spoke about LGTBI, we got a very lengthy presentation about this I intersex, and therefore I am personally willing to hear about the scientific proof when life starts to really speak about the right to life, which is, it has been already a practice concerning intersex. And then there is also a counter logic concerning what has been said by Mrs. Cleveland and Monsieur de Prouville. Because when we speak about abortion, I think that we should focus on the awareness for women, that women should be aware that if she will get pregnant, she can go to a clandestine abortion, and then she can risk her life. And therefore, from the start, she should avoid getting pregnant, and she had all means not to get pregnant, and therefore to avoid all this issue of abortion and risking her life from the fact of abortion, as was stated that now the example of South Africa, we can avoid all that from the start, this issue of illegal abortion, and just have awareness of the ladies that there is a way not to go for clandestine abortion and to prevent the pregnancy from the start. Thank you, Mr. Chair.
Thank you very much indeed. Unfortunately, we are out of time. I do have 2 requests for the floor, and I wouldn't want to silence colleagues. Thank you very much indeed for all of you for participating. I would like to give the floor back to the rapporteurs at this point to wrap up this debate, at least for the time being, and then we will suspend the meeting. Mr. Shani, you have the floor.
Well, I will just thank all colleagues for their very interesting and important contributions. I think it is too soon for us to wrap up, because we haven't heard every member who would want to speak on the general issues. I hope that in the next session we will also receive specific drafting formulations, so that we can channel the collective views of the committee into a specific text, which is, after all, the purpose of the issue. I will just perhaps say that, well, maybe I will stop here. I did want to say something, but I forgot, so it's probably not important.
Gracias.
I did remember, sorry. Just to respond to Mr. Stidelsing, and that is, even if we postpone, if we decide to push, I don't think it would be good for us not to deal with this in this session. So I would not use postpone, even if we decide to postpone the text, I wouldn't want us, as a result, to stop dealing with it now and have the whole thing come back to us again in a year or 2 or 3 years. So we should try to deal with whatever we can with this text now.
Sí, por supuesto, ya.
Yes, of course. This is the debate, and we will move forward with that. Sir Nigel, please.
Again, just very briefly, I take very seriously the suggestions from various quarters to relocate the text, and I think it would probably be unwise of us not to take that suggestion on board, just to indicate that there's more than one possible place, and I'm not necessarily indicating indicating that I or we have taken a position yet. But one possible place would also be in the final chapter where the right is linked to various other rights. Mr. de Fourville has mentioned Article 17 and 19. Of course, Article 7, the right to be protected from cruel, inhuman, or degrading treatment, is one that is particularly apposite in this area. And so, and indeed has been part of our jurisprudence. So that's also another possibility. I'm not saying that we genuinely haven't discussed between us where the relocation should be, but there's more than one possibility is the only point I'm making. Thank you very much.
Muy bien, muchas gracias.
Thank you very much. I had a point of order. Mr. Benachur?
Merci.
Thank you, Mr. Chairman. Thank you for kindly giving me the floor at this point in proceedings. I wanted to make a proposal for next week. Next week, we are going to have two lengthy discussions on the general comments in Article 6 on Monday at 3 p.m. from 3 to 6. And then the next day, Tuesday, as of 10 a.m. Now, am I wrong? The Chairman. Yes, it's what I said at the beginning, in fact. The programme of work has been modified, and the next time that we will be looking at the general comment is on Friday, Friday the 18th, in the afternoon. So the Monday and Tuesday sessions have been cancelled? The Monday and Tuesday sessions on the general comment?
El martes.
Tuesday morning, yes, we will be looking at the general comment. So, we have a session on Friday afternoon and then Tuesday morning on the general comment. This Friday.
Pourquoi je pose la...
Right. That explains the doubt I had in my mind. I'm sorry, I didn't quite grasp that change. I'll just explain why I was asking the question to start with. The working group on communications had some major issues to address surrounding very much the issues we are discussing under paragraph 8 of the general comment. And the question I'm asking is as follows. Would it be possible to somehow fit in our meetings on communications and on the general comment from the rapporteurs such that we can make inroads on this communication before we begin the discussion on the general comment? That's why I'm asking this question, because it's a fairly groundbreaking case, I think, this one, and it might shed light on the general comment.
Muchas gracias por la sugerencia.
Thank you very much for the suggestion, Mr. Chair. I don't know if that'll be possible, because we do have states parties programmed this week, but I dare say the colleagues will take into account various elements and feed them into the debate on the general comment. And at the same time, I do not wish to make reference in public session to the content of a draft communication. All right. On that note, I would like to suspend the debate on the general comment. Thank you very much to all colleagues who participated in this. Thank you to the rapporteurs, of course, for the colossal efforts. This is the hardest job a committee member has, to be a rapporteur for a general comment. There is no doubt about that. Thank you very much indeed to both the co-rapporteurs. I would like to suspend the meeting. We will then move to private closed session, and we'll be holding a meeting with national human rights institutions for the states undergoing examination this week. I would like to suspend for 5 minutes.